Thank you so much, everyone. We're going to get started with, you just heard the view from the bench. We now have the view from the bar from a wide range of practitioners, backgrounds, and experiences and vantage points. And to get us started, Professor Jonathan Peters. John Peters is the Associate Dean for Academic Affairs and the Carter Chair for Excellence in Journalism at UGA's Grady College of Journalism and Mass Communication. Also holds a faculty appointment at the School of Law. His research focuses on media law and policy and appeared in journals published by law schools at Berkeley, Harvard, NYU, Virginia, North Carolina, among many others. He's the co-author of the book, The Law of Public Communication, and he's a frequent commentator on media law issues for the New York Times, the Washington Post, and many others. So thank you, welcome, Professor Peters, and let's get started.
Thank you, Frank. Welcome back, everybody, and thank you for being here for the panel, The Rule of Law in Challenging Times, 3 Perspectives. Our focus today is going to be on the view from the bar, how lawyers are navigating an era of political polarization, declining trust in institutions, rapid technological change, and sustained challenges to legal norms. For much of American history, the rule of law has rested not only on statutes and court decisions, but also on shared expectations. Expectations about independence, fairness, professional ethics, restraint, and good faith. Many of those expectations are now under strain. We are living at a time when legal institutions are routinely questioned. Lawyers and judges face personal and professional attacks. Disinformation spreads faster than fact in far too many cases, and legal tools are increasingly used as political weapons. At the same time, lawyers remain essential guardians of democratic norms and rights, whether serving in government, private practice, public interest organizations, or in academia. Today's panel brings together 4 people who have engaged these issues from different vantage points. Within government institutions, major law firms, in election administration, and in public interest advocacy. Seth Kirschenbaum is a partner at Lotito and Kirschenbaum, and he started his career at the firm now known as Kilpatrick Townsend. From 1979 to 1984, he was a federal prosecutor working for the Antitrust Division, and then the U.S. Attorney's Office for the Northern District of Georgia. His private practice since 1984 is focused on criminal defense, including matters related to public corruption, antitrust, mail and wire fraud, healthcare fraud, drug trafficking, and murder. He's a past president of the Atlanta Bar Association, and for 20 years he was a member of the Board of Governors of the State Bar of Georgia. Next is Sara Zdeb. She is a visiting assistant professor of practice at Emory School of Law. Before joining the Emory faculty, she served as Deputy Assistant Attorney General for Legislative Affairs at the U.S. Department of Justice, where she managed the DOJ's response to high-stakes investigations by Congress. She also served as Chief Oversight Counsel on the Democratic staff of the Senate Judiciary Committee, where she led investigations of the DOJ, the FBI, and other executive branch agencies. Prior to her public service, Sara was in the white-collar defense and government investigations practice of O'Melveny and Myers. Next is Edward Lindsey. He's a partner in the Dentons law firm in the public policy practice, and he serves as head of the Georgia State Government Affairs team. He focuses on advancing the public policy interest of clients in such areas as transportation, infrastructure, healthcare, election law, and education. He has more than 41 years of legal, political, and leadership experience, with 10 years as a Georgia State representative and 3 terms as the House Majority Whip. His volunteer work includes service on the State Election Board, and he's a member of the board of the Elected Officials Legal Defense Network. Finally, Peter Simmons is the Georgia policy strategist at Protect Democracy, which is a nonprofit organization that uses litigation, advocacy, research, and technology to defend dissent, protect elections, and build a thriving multi-party democracy. He is a policy professional and attorney focusing on governance and constitutional issues with an emphasis on policy advocacy and analysis, coalition building, and navigating the legislative process. He has held advocacy and legislative roles in the United States and abroad, where he honed his legislative drafting and analysis skills. My role this afternoon is to guide a structured conversation, and our goal together is not a partisan debate. It's professional reflection. What is happening? Why does it matter? What can lawyers do, both individually and collectively, to defend the rule of law? To begin unpacking those questions, I'd like to start with you, Seth, and focus on the DOJ for a moment. How has the Department of Justice been impacted by the current administration? And then what changes, formal or informal, stand out to you?
Well, thank you, and thank you all for being here. Could I just divert 1 minute to say that about 10 months ago, a group of lawyers started something called Georgia Lawyers for the Rule of Law, and we now have over 800 Georgia lawyers who have joined us. And if you would please get out your cell phones and go to Georgia Lawyers for the Rule of Law and look us up. You can join us, it's free, and we are the only organized group of lawyers who are speaking out in Georgia in defense of the rule of law. The Justice Department is about 150 years old, and over that long period of time, it developed a well-deserved reputation as a professional organization of the highest ethics and integrity. And as was said, I was a trial attorney and a federal prosecutor for 6 years with the Department of Justice, and it was one of the highest honors of my career. I mean, when I got the opportunity to stand up in court and say, Seth Kirschenbaum for the United States of America, I was busting with pride. And I can tell you that, and I was working for the Justice Department back in the dark ages, in the 1980s, but I can tell you with certainty that if anyone in my offices ever lied to a federal judge, they would have been summarily fired. But we have a situation today, unfortunately, where Justice Department lawyers have misled courts, lied to courts, defied court orders, and there have been documented cases around the country where judges have found that lawyers for the Department of Justice are not being truthful. And there's something in the federal courts that was developed over the course of many years. There's something called the presumption of regularity. The presumption of regularity was that because of the integrity of lawyers for the Department of Justice, judges would accord lawyers the benefit of the doubt. If a lawyer from the Justice Department made a factual representation to a judge, it would be assumed that that was an accurate representation. It's called the presumption of regularity. And in case after case around the country, courts have announced that they will no longer, in these specific cases, accord the Justice Department the presumption of regularity. They're requiring the Justice Department to prove allegations of assertions of fact in these particular cases. And that is a sad thing to report. We have an Attorney General who has attacked judges personally. The Deputy Attorney General, a former criminal defense lawyer for the President, declared in a recorded statement to a group of lawyers that the Department of Justice is at war with the Judiciary. The Department of Justice has, at the instigation of the President, targeted political enemies of the government with indictment in highly questionable cases. Pamela Bondi sued the entire bench of the District Court of Maryland, unprecedented, because she didn't like their rulings in immigration cases. And she threatened to investigate a judge named Judge Boasberg because in a private meeting of judges, he wondered out loud what would happen to the rule of law if the Department of Justice defied court orders. And we now know that there's been something like 4,500 court orders that have been defied. There's an order out of Minneapolis from a judge that said that the Department of Justice and ICE had defied more court orders in 1 month than is in many, many years. So there is a situation that we're facing today where the Department of Justice is under extreme pressure, and many career prosecutors have been fired or forced out. whole departments, whole groups within the Department of Justice, such as the group that enforced tax fraud, and another group that enforced the Foreign Corrupt Practices Act, which makes it illegal to bribe foreign officials. Those groups have been decimated. There used to be an ethics person in the Justice Department who advised federal prosecutors on ethics. That person has been fired. There is no ethics person in the Justice Department anymore. So the Justice Department is under a lot of pressure, and there's a lot of problems over there.
Sara, if I could build on that, why are norms beyond formal law so central to the DOJ's independence and legitimacy? And then just kind of a double barrel to the question here, how are those norms being challenged?
So I will answer that, but before I do, I wanted to just put a bit of a finer point on a couple of the items that Seth was talking through in terms of the decimation of the workforce at the department. So around this time last year, folks may remember there was a significant amount that we were all reading about, watching in the news regarding DOJ and all of the wholesale cuts that were being made across the federal workforce. That hasn't totally happened at DOJ. What has happened at DOJ has looked a little different, but is no less problematic. At DOJ, what we have seen includes a very deliberate targeting through a campaign of retribution against individual prosecutors, attorneys, and FBI agents who worked on cases that are now disfavored. In addition to those people who were fired from the department, a large number over the past year of agents, prosecutors, litigators have left the department because they either have been or are concerned that they may be asked to do something that they view as unlawful or unethical. And just to put a couple of numbers around what we have seen, and it's a little difficult to get totally accurate information, but there is an organization founded, in fact, by an Emory Law alum called Justice Connection that was stood up last year and is serving essentially as a support network for the DOJ workforce. And based on their latest data, we have seen approximately 6,500 department employees who have left the department, either voluntarily or involuntarily, since around this time last year.
Would you mind moving the mic closer to you?
Yes.
Thank you.
Does that help?
Much closer.
It's literally right in front of my face.
That
Is that better? Okay, great. Okay, so since this time last year, we've seen around 6,500 employees of DOJ who have voluntarily or involuntarily left the department. This includes roughly 800 FBI agents. It includes about 75% of the Civil Rights Division. As I said, these employees have left for different reasons, but at a high level, what we have seen is an absolute decimation of the apolitical career workforce of an institution that is responsible for upholding the rule of law, keeping our country safe, and protecting civil rights. Okay, so to answer Jonathan's actual question, which had to do with norms. Since Watergate, the department has worked really hard and has stood up a number of internal policies and norms designed to restore public trust in the institution that was decimated after the abuses we saw in Watergate, and to essentially kind of reinvigorate public confidence that the department would enforce the law in an impartial, even-handed manner. And so these norms include, just as a couple of examples, something called the Principles of Federal Prosecution, which are a set of internal norms and requirements that guide or are supposed to guide the department's decisions about when to prosecute, and just as critically, when not to prosecute. The norms also include, at a very high level, the basic principle of independence. An independent justice department. And so this manifests itself, or historically, since Watergate, has manifested itself in a number of norms, but to take just one example, there has long been a policy that restricts contacts between the White House and the Department of Justice in recognition of the fact that it is inappropriate and harmful to public trust in the work of DOJ if DOJ is seen to be doing its job at the behest of the White House for political reasons, as opposed to based on the facts and the law. And then finally, another norm that I think is worth noting, because we are in Fulton County, it's actually a series of longstanding norms at the department around the appropriate role of the Justice Department and federal law enforcement when it comes to federal elections. None of this is enshrined in law, but it has long been enshrined as a matter of internal DOJ policy and internal norms that it is not appropriate for DOJ to insert itself into federal elections unless absolutely necessary. And that norm reflects an acknowledgement that the mere fact of DOJ standing up and saying we are conducting an investigation can have enormous ripple effects on public confidence in the administration of elections. Those are just a couple of examples of norms that have existed at the Department of Justice across administrations of both parties, dating back at least as far as Watergate. But they are just norms. And so the thing with norms is that they are only as strong and effective as the people who are charged with their implementation are committed to implementing them. And so each of the norms that I just identified, among many others, are being stressed and tested in new and very unprecedented ways these days. Seth mentioned a couple of examples, but I'm sure I don't need to kind of run through the litany of examples that we have all seen in the news about individuals who have been singled out for criminal investigation and prosecution, seemingly because they disagree with the current administration. The recent action in Fulton County around ballots from the 2020 election, and then just in general, the consistent statements that we see out of the White House weighing in on specific investigations and prosecutions, effectively instructing the Attorney General who to investigate. Those are all wildly inconsistent with these longstanding norms that I have mentioned. But again, because they are just norms, we are fully dependent on the people at the Department of Justice and across the executive branch to operate consistently with them or not.
Thank you. Peter, from the advocacy side, how has the current political and legal environment changed your day-to-day work as a policy counsel?
Oh dear. Originally when I returned to the States for my last gig, I was very centered on what I guess would be traditional policy counsel duties. I drafted legislation, I created the equivalent of committee reports and explained the law to people like Ed. And as things have become more unconventional, my strategies have had to adapt. So I am able to make incursions in coalitions that may not normally want or allow my presence. I'm able to take non-traditional advocacy routes like going through county commissions or county boards of elections to pass regulations, as well as working with other non-governmental but still authoritative associations like the bar to work with practitioners and other professionals to curtail some of the lawlessness and norm-ignoring activity that we've seen from all levels of government. Does that make sense?
It absolutely. Ed, you have a lot of experience in election administration and in running your own elections.
Yeah.
How have you seen institutional stresses affect public confidence in our elections and in the rule of law more broadly?
Yeah, well, yes, I have 5 elections under my belt as a candidate, and also have almost 2.5 years on the state election board under my belt. And before I go any further, is Bill Duffy still here? I don't know if Bill mentioned to you, but he served on the state election board with me for a little over a year, and then he ran off and went to seminary. That ought to give you an idea of what the service on the state election board can do. Yeah, I mean, what's scary is that we have an enormous erosion of faith in our elections, and that is a cornerstone of democracy. The need, quite frankly, for whoever lost an election, I'll take it back. I have 6 elections under my belt. I'm 5-1. I lost one, and the last one when I ran for Congress. And that's important to this story because it was so important for people who worked so hard for me when I ran for office that last time, to hear me step in front of them and congratulate the winner and accept the results and say that they fought hard and we're gonna accept the results. That is a cornerstone of democracy. That is one of the cornerstones of democracy is the acceptance of the outcome of the elections. You know, granted, there are some elections where they are tight and you got to go into court and prove that maybe there was a problem. But short of that, it's extremely important for public officials or anybody who runs for office to respect the system and to respect it. And what we've seen in recent years is an enormous erosion of that, in which folks want to constantly be trying to figure out one conspiracy or another. And since you raised Fulton County, I'll raise Fulton County. How many of y'all read the affidavit that went along with it? About a dozen. I'll let you know a little secret. While I served on the state election board, we investigated each and every one of those issues that is raised. We came away with some random acts of fraud, not systemic, but some random acts of fraud. We came away with a lot of misfeasance. Keep in mind, the 2020 election was the most challenging election for people who run elections during our lifetimes. Probably not since 1864, when we were involved in the Civil War, have we had an election that had so many challenges in terms of the pandemic and the infrastructure just simply wasn't in place to deal with a lot of the mechanics. You know, we're used to dealing with, for instance, absentee ballots coming in somewhere around 4 or 5% of folks who vote. That year, in the primary, it was close to 50%, and in the general election, it was somewhere between 30 and 35%. So a lot of what you've seen and heard about in terms of the chaos surrounding the counting and the results of the 2020 election resulted not from malfeasance, but simply the fact that the infrastructure was under enormous stress. And what's challenging and what's scary is that truth travels by wagon train. Conspiracies travel by the speed of light. And the fact of the matter is, for every time we knock down an allegation, whether it be 2000 Mule, which actually in the end, due to our efforts, they actually had to pull it from active scene, to the myriad of other things that you would have read about in the affidavit, we came back and found, yeah, okay, we had a mistake here, a mistake there. How do we fix it? How do we make sure it doesn't happen again? And confirm the fact that it didn't change the outcome of the election. But that didn't get reported too often. And the conspiracy folks simply moved on to another conspiracy. It became a game of whack the mole. And it's still a game of whack the mole. Like I said, and it's like Hydra. You cut off the head and 2 more appear. When I read the affidavit, I was sitting there going, well, okay, here we go again. And so it is disturbing. And what happens along the lines, and you know, we talk about federal prosecutors, talk about judges feeling under attack. Let's go down several levels. A lot of the work that's done to make the system work are done by people who are anonymous, by the clerical people, by the volunteer who volunteers at a polling place, by the county election board members, state election board members, people who are by and large anonymous. They don't want to serve. A large number of people I've had come to me and say, you know, when I served on the state election board, and I was talking to various county officials going, I'm resigning. I can't take it anymore. I mean, these are people that come every year and they accuse me of all kinds of horrible things, and you know, I got a life. And then you've got clerical people who are running the elections, who don't have a lot of the protections and recognition, and they don't make the press, but they're scared to be part of the system. Jurors, you know, continuing lawyers, jurors are a lot of times resistant in high-profile cases to be part of, because they know the abuse that they're going to be subjected to. So that's the danger here, is the inability of folks to accept results. And if you don't agree with results, there is a established way to deal with that through the court system or through politics. But you don't demonize folks simply because you were on the other side. And what scares me to death is that loss of that infrastructure, in addition to the folks in the Justice Department, in addition to the lawyers, in addition to the law firms, in addition to the judges, the folks who are just trying to have a, you know, they accepted public service. They probably could have gotten better work somewhere else, but they accepted public service, and yet their public service is demonized. And we saw that in the 2020 election, and we continue to see it to this day, and that's what scares me to death. Because I saw those people on a first-hand basis during my time on the state election board, and I'm scared to death for them.
And if I could follow up with you once more, you drew the kind of analogy to the wagon train and the speed of light, you know, at the heart of the problem of misinformation and disinformation. What can lawyers and institutions do to try to combat that problem, the problem of mis and disinfo around elections?
Well, let me make a little guess here, Seth. You and I haven't voted on the same side too often in our respective lifetime.
Correct.
I belong to the group that he talked about.
Georgia lawyers for the rule of law. A nonpartisan.
A nonpartisan group. A lot of it is for us to stand up and be counted, and to push our law firms to stand up and be counted, and to push back. And it can be big things like some of the things that I've been talking about. It can be little things. I get sick and tired of every time a decision gets handed down to be told who appointed the person. Okay? You know, most judges I know leave that at the door. A few don't, but most of them that I know leave it at the door and then go do their jobs. I mean, that's just a small example. It's for us to stop perpetuating and to push back ourselves when we hear it. A lot of times it's a lot easier just to let it go and to move on, but we are at a crisis point now, I think, in our society where we can't simply walk away. That crackpot uncle that we used to see at Thanksgiving, he's all over the place. And we have to be prepared. We're lawyers. We should know how to advocate. Let's stand up for our profession. Let's stand up for the little guys and gals who are doing their jobs. And let's push back. It's simple as that. And as hard as that.
And if I could say that, you know, there's a lot of fear in our country right now. I mean, people are literally afraid to speak out. And if they see powerful people like U.S. senators and U.S. congressmen and women, you know, threatened with indictment because they held a press conference and told the truth and accurately quoted a law, then people might think, well, gosh, if they can go after a U.S. senator, or they can go after the governor of Minnesota, or maybe they could go after me. And so people are afraid, and we've seen it. To Ed's credit, he's in one of the biggest law firms in the world, and he joined our group. But some of the biggest, most powerful law firms in the country were attacked, and they cowed. You know, they bent the knee, and they are sitting this one out for the most part. We don't have a lot of members of Georgia lawyers for the rule of law from big law firms because they're afraid. And some of the richest, most powerful universities in the country have bent the knee because they're afraid. They've been threatened with annihilation. Major media companies have thrown tens of millions of dollars at to settle frivolous lawsuits because they're afraid. And one thing we as lawyers have is our voices and our expertise. And lawyers take an oath to protect and defend the Constitution. And that's something that we all have a responsibility to do. And speaking out takes courage. Sticking your head above the parapet takes courage because you might get it blown off. But that's what lawyers should be doing. And by that I mean, we put out articles every week about rule of law issues, and repost our articles to your LinkedIn accounts. Talk to your neighbors, talk to your colleagues, tell people this is not normal. There are things going on that are dangerous to our system, our government. Lawyers have that responsibility.
Let me, if I can add one other thing that I think is very important. Stand up to your friends when they do wrong as well. I like to quote Dumbledore. It takes courage to stand up to your friends. It takes courage to stand up to your enemies. It takes even greater courage to stand up to your friends. There will be times in which your allies, your friends, politically partisan community, that will also push in the wrong direction. And we've seen some of that over the last few years. So it's important for you and I to not only stand up to those that are easy for us to stand up to, they are our opponents in many respects, but to also stand up to our friends when we feel that they've crossed the line. I think that's extremely important for us. In order for us to truly have that moral authority, we have to call out everyone that's on both sides of the political line. Obviously, what's going on in Washington has all the headlines, and I'm as appalled as the other folks on this panel are, but we can't allow anyone on either side of the political spectrum to get away with it.
Sara, I'd like to go back to you. Seth talked about how we've seen increasing political and economic pressure brought to bear on lawyers and law firms with references to big law. If we go back to the DOJ, though, for lawyers who care about the DOJ's independence, what practical steps can they take in the current environment to support that independence?
So I've got a couple. First, I fully agree with the importance of standing up and being counted. And so if you value an independent Department of Justice and care about what is happening, then as lawyers, by all means, stand up, be counted, make your concerns known. Going back to a point that was made on the earlier panel about immigration, creating a record, I think is also important, particularly and I'm going to be optimistic, that we will return to a point where we're in a place of being able to rebuild institutions like DOJ. So in the interim, creating a record of things that have happened that are contrary to norms and what all of the values that those norms serve is important when and if we do end up in a place of rebuilding. The final thing I'm going to say is maybe a little controversial given the topic of this panel, which is the rule of law. And at the risk of upsetting Seth and others who are justifiably quite focused on rule of law, I think if we're lawyers who care about an independent Justice Department, we have to stop only talking about the rule of law. We're all here in this room because we care about the rule of law. Lawyers in particular understand why the rule of law and things like an independent Justice Department are critically important. But the reality is that these concepts can feel a little bit amorphous, I think, to people who aren't in our shoes and have not devoted their lives and careers to upholding the rule of law in the way that many of us in this room have done. And so in addition to doing all the things that Seth's group is doing and standing up and being counted and creating a record and focusing on attacks on the rule of law, if we care about the Justice Department in particular, we need to talk about the underlying work that it does and how that work is being harmed in a way that is tangible to people and and relates to issues that they care about in their communities. And I think, by the way, I'm speaking both to the lawyers in the room, but also perhaps to the members of the media in the room. It's very easy to talk about the latest outrage, which presidential political enemy was indicted or is being investigated. But the reality is that the decimation of the apolitical career workforce at the Department of Justice and the FBI is also going to make it really hard for those institutions to fulfill their core functions of protecting communities from violent crime, from fentanyl, of protecting civil rights, of combating terrorism. And you can sort of go on and on about the different substantive things that the Department of Justice does. That type of work can potentially be a little bit more relatable and tangible to people who might not ordinarily be as motivated and concerned about the rule of law as we are. And so as lawyers and as reporters, as we talk about what is happening at DOJ, I would encourage us to talk not just about the rule of law, but also about how those attacks undermine the ability of the department to protect civil rights and keep communities safe.
So since you called me out,
Yeah.
I would say go to our website and read some of our articles. I mean, well, you might be surprised to see that a lot of our articles do just what you just suggested. And because we are trying to make our content relatable to people, how is this going to affect you and how is it going to affect your community? I totally agree that we have to make that relatable. But when we formed our group, we were saying, well, we can't solve all the problems in the entire world, but we are lawyers, and we know about law and the rule of law, and so we had to narrow our focus to something that we could do. But I will point you to a group of former Justice Department lawyers who formed something called Justice Connection. And Justice Connection is creating these like 1 to 2 minute videos made by former Justice Department lawyers who are talking about how the work they did at the Justice Department is being gutted by this administration and how that's impacting on the real world and real world people. So there's a lot of things going on out there that are trying to educate people about what's going on. And I'll just say one other thing. One of the things we're doing at Georgia Lawyers for the Rule of Law.org, in case you didn't hear me say that before, is we have a speakers bureau, which is, we now have about 45 lawyers who have signed up to be speakers, and we want to engage in civic education, because there's not only are there lots of lawyers who don't really understand the separation of powers, but unfortunately there are vast numbers of regular folks who don't really understand the separation of powers, the role of an independent judiciary, how cases proceed through courts. Basic stuff about civic education is not being taught in our schools, and without a basic understanding of what our system is supposed to be, how it's supposed to run, then people may say, well, yeah, those unelected judges are making bad decisions when they don't know that these judges were appointed for life. So we do have a civic education component that I think is very important.
I just want to mention, too, that I really appreciate Seth's message discipline up here. That is very impressive. My dad was in advertising for a long time, and he said that there were 3 rules of advertising. You have to tell them what you're going to tell them, then you tell them what you told them. And so I think, Seth, you and my dad are cut from the same cloth. So, Peter, I've got a question for you. We've largely framed this period of uncertainty as restrictive and kind of scary. But what advocacy opportunities has the current moment presented for your work, maybe toward the end of democratic reform?
Well, first, I'd like to say my comms team would kill for me to be a quarter of as on message as that. But it has surprisingly created quite a few opportunities that I don't think were available before. And I mentioned some of them previously, but to Seth's point, civic education. I primarily do grass tops work. I talk to members of Congress, members of the legislature, regulators, but lately I've had the opportunity to speak with normal citizens who don't spend all their time reading the Constitution and hanging out with Seth and Ed and Sara and doing things that are much more relatable to the general populace. I think, frankly, Seth hit it on the head. If we create an educated population that understands how the system works and understands the rights that they have and where the lines are drawn, we can kind of short-circuit this whole degradation of the rule of law entirely. And I think bringing that deficit to the forefront has created open minds where previously there were none. I mean, you know, as much as I love drafting white papers, I think going to my neighbor and maybe a one-pager or a PD one-pager, which is really 6, has been much more effective in moving the needle and creating a voting population that does not want to be run over, that does want norms to be respected, and wants the election infrastructure to hold. And I think that by viewing some of this fear and desperation as, I guess, a catalyst for change, we've been able to, you know, mine what I would call previously unfertile ground very effectively. Does that make sense?
It does. So at this point, we've got about 7 or 8 minutes remaining, and I'd like to open it up to audience Q&A. So if you would, if you've got a question, make your way over here to the microphone.
Hello, and thank you all for all your comments and all your participation. My question has to do with the upcoming midterm elections, and the president has said that the elections should be nationalized, which I think is unconstitutional. In addition, there have been members of his administration who have said that ICE will be present at many of the polls in the upcoming elections. My question to you all, especially maybe Mr. Lindsey, who I covered years ago when you were in the legislature, by the way, is, are those things legal? Would it be legal for ICE to be present at elections if, in fact, they disrupt the elections or are designed to prevent people from voting? And if so, if they're illegal, what should be done now, or what could be done now to ward that off?
Well,
thank you.
First off, is it legal? Probably not. And it's also questionable because the illegal alien, someone here, undocumented, can't vote. So I don't know who they're supposed to. And contrary to what you've heard on the press and by some folks in this administration, someone who votes who is not in this country legally, or for that matter, in the country legally but is not a U.S. citizen, is extremely rare. And I'm going to emphasize the word extremely rare. Even the Heritage Foundation, which has a list of fraud over the last 50 years, I think they have like maybe 70 or 80. I must be going too high or too low, but right about that number over like 50 years. The fact of the matter is, if you want to get yourself in trouble and you're not in this country and you're not either legally or you are not a U.S. citizen, go try to vote. Because why would you do that? That will, and it just doesn't happen. Not in a systemic fashion. Yes, there are some occasional folks that may try to do something stupid. But by and large, you know, you kind of wonder what, other than intimidation, what's going on. When it comes to federalizing elections, that's not only illegal, but it's stupid. And the fact of the matter is the number one protection against widespread fraud, changing a state election or a federal election, is to nationalize it, or for that matter, have the state take it over. To give you an example, Georgia has 159 counties. We have 159 county election boards. They run the elections, okay? And that is actually a very good safeguard. Now, you do have occasional counties that do bad things. Coffee County did something. But by and large, these folks are working very hard. And by virtue of the fact that they are all autonomous, makes it very difficult to pull off the kind of systemic fraud that you are having people claim is taking place. So, the fact we have a decentralized election system, I think is one of the best guarantees we have in this country to keep that kind of systemic fraud changing large elections.
I'm just worried about intimidation. I mean, the purpose of putting ICE at election locations is to intimidate people. And I might not be intimidated as a white man from going to that polling station, but what about a U.S. citizen who's Hispanic? Might that person think twice about voting after seeing what happened in Minneapolis, where anybody who looked Hispanic was in danger of having their car window smashed and forcibly pulled from the car? So, I mean, that suggestion that they're going to have ICE is chilling and scary and dangerous, and is part of the, a policy of intimidation, which I find incredibly disturbing.
But are there any things that can be done now to prevent that? I mean, are there any lawsuits? Are there any challenges? Are there any anything that lawyers can do? I've heard that in some states, lawyers are being mobilized to be present at polls or to witness this kind of...
I do believe both political parties have a cadre of lawyers on staff, volunteers usually, to answer any kind of threat that takes place, or perceived threat that takes place. And yes, they go for both sides of the split block. Regardless of what political party you belong to, as a lawyer, if you're looking for something to volunteer for, suggest that to be able to protect. Because Seth is actually right, and I didn't focus enough on that. Is there a legitimate purpose for them being there? No. Is there a reason for them to be there? Yes. And the reason is intimidation. But yeah, I mean, you get involved in various groups. There's also nonpartisan groups that deal with both sides, make sure both sides behave. So yes.
They're having a double of a time keeping ICE out of churches, schools, and hospitals. So they're pushing the boundaries as far as they can go, and polling places is a logical next step.
But most of the problems with elections take place because of mistakes. And it shouldn't happen, but they do. Polls placed late, something happens, whatever else. So yeah, I mean, there's a good reason for folks to run to court. Like I said, fight hard against anyone who wants to see the system alive. That's how you reform a true reform.
And just on elections, on our website, there's an article by Al Pearson, who's a retired Georgia law professor, called Elections in Georgia, Why They Can Be Trusted. And it is an extremely well-researched, scholarly article. That's a little too long, but it's we printed it anyways because it was so well thought out and well executed. And it refutes any possible argument that any rational person could make that there is a problem with our election administration in Georgia or the country.
And that's Georgia Lawyers for
Georgia Lawyers for Law.org. You can get it.
Thank you.
Yeah, I just know the fact that he was a brilliant professor who gave me a
We've got about 1 minute, so we'll see if we can do this speedily. Go.
Okay, Walter Reeves report, reset. I'd just like to say that during the Atlanta mayoral election last year, I did land on Merrick Garland's top 10 list when I called in a truck attack 3 days in advance. I expected to have him here for a peach drop, but unfortunately it happened there in New Orleans. And also, in 2023, I passed an extensive federal moral turpitude investigation by the National Security Division and by the same team that investigated Hunter Biden, and I passed. We're just grateful for y'all. God bless y'all.
And like I said, stand up, both sides.
Okay, well, thank you very much. Once again, and please join me in thanking the panelists for their time and
thank you, John Peters, for your usual magnificent job and landing us on time. So please don't leave. We have one more wonderful panel coming for you. You don't want to go out and try to traffic anyway. And we have drinks afterward for those of you who are able to stick around. But if the folks from the view from the newsroom will please make their way up front. We can get started in 10 minutes. 10 minutes.